the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files, episode 29, with Leslie Tucker, the principal of Williams, Edelstein, and Tucker, and I am your host, Jonathan Saar. We're glad to have everyone back with us today. Today, we are going to discuss a critical fair housing case that sheds light on the importance of reasonable accommodations and the responsibilities of property management professionals. The case we're reviewing today is United States versus Kailua Village Condominium Association, and it's a great example of how mishandling requests from disabled residents can lead to serious legal consequences. So to help us understand the details, we have Leslie, an experienced fair housing attorney, and she's awesome. Thanks for joining us, Leslie. Good to see you.
Thanks, Jonathan. Glad to be here. Yeah, this is an important case.
So to get us started off, what was the situation at Kailua Village Condominium that led up to the lawsuit?
Well, it started with a resident who was purchasing one of the condo units at Kailua Village. This resident has paraplegia and uses a wheelchair. Due to his physical disability, he requested a couple of reasonable modifications prior to moving in. One was the installation of a ramp just to access his unit, because there were a number of stairs at the property leading up to what would have been his door. And a different toilet is another thing that he requested. He also requested a different parking space that had some additional space off to the side to enable him to get in and out. The space that was deeded to the unit that he was purchasing was positioned so that he would not be able to get in and out of his vehicle. So he needed a space kind of more off to the side with additional space. So those are the things that he requested prior to the purchase.
Okay. Well, that sounds standard, straightforward. What went wrong?
Yeah, I mean, I agree that those are kind of pretty common requests. What happened was that the condominium association not only allegedly denied the request for a reserved parking space, but they also refused to allow him to install a ramp to access his unit. They argued that, they had policies that didn't allow for those types of modifications, really, even though it would have been the resident who was responsible for getting that work done and paying for it.
Okay. So if I remember right, it wasn't just a denial. They actually tried to get him to change his mind about living there. Is that right?
Yeah, and that's an important part of the allegations in this complaint. After the resident requested those modifications and the accommodation parking space, the association allegedly tried to pressure him to reconsider his decision to even purchase the unit in the first place. They, among other things, allegedly suggested that maybe this complex wasn't the best fit for someone like him, which of course, amounts to not only discrimination, but also steering, which is illegal under the Fair Housing Act. And also, unfortunately for the defendants in this case, there were a number of internal emails among the different association members that really documented their plan to discourage him from purchasing. And that was all evidence that was brought in during this case.
Yeah. Okay. So pretty clear, fair housing violation. So after being denied accommodations and facing that kind of pressure, what did the resident do?
Well, the resident did ultimately back out of the sale of the condo and then filed a fair housing complaint with HUD. HUD investigated. They did find cause to believe that these actions were discriminatory. And then this lawsuit resulted. And the Department of Justice filed this lawsuit against the Apartment Association, the individual condo owners, among other entities as well.
Okay. So let's break it down for a moment. So we got multiple layers of discrimination here. One, denying reasonable accommodations. Two, refusing to allow modifications to make the unit accessible. And then three, trying to discourage the resident from living there at all. So how did this all play out in court?
Well, this case did settle. It ended up in a very large damage award. And ultimately, the condo association was agreed through this settlement to pay $125,000 to the resident and other potentially affected individuals from these types of policies. They also had to pay a civil penalty to the government of $25,000. And of course, all settlements incorporate some kind of changes to policy, to training and things like that.
Yeah. So that's a decent chunk of change. That's a substantial settlement. Yeah. So what do you think property managers and condominium associations should learn from this case? What are your thoughts?
So housing providers need to, I guess, sort of recognize that these types of requests for reasonable accommodations and reasonable modifications, whether it's for a ramp or a parking space, it's really not optional as long as you know that there is a disability-related need for these changes. In this case, there was no question. The resident has paraplegia, uses a wheelchair, could not access his vehicle or his unit without these types of changes. So it's not a choice. It's not an option. You are required to meet these needs or allow the resident to make these changes, right, out of their own pocket if you are a conventional property. Secondly, the association's attempt to steer this resident away from this property really, if true, was discriminatory under the Fair Housing Act. They are essentially kind of discouraging the sale of this property completely, allegedly based on this resident's physical disability. That would be steering, which is when you are pushing someone towards another property, towards a unit, towards a section of your property because of a protected category. Housing providers legally are supposed to make all residents feel welcome, equal, and work to accommodate those residents based on their needs. And lastly, I think the sort of elephant in the room here is that there's a very good chance that the people involved in this case had not participated in fair housing training, maybe didn't realize what the law said, and what was required of them as association members making these types of decisions. So, a lack of training can really lead to pretty harsh financial consequences.
Yeah. So that makes a lot of sense. It's clear that these situations, they require careful handling, a real commitment to fair housing principles. And I love that word, principles. I mean, that really, before you start getting into policies, it's like, what's the culture like? So what's the advice for property managers who are watching this video?
So the simple advice is take these accommodation requests seriously, engage in the interactive process with the resident. If they're asking for things that you're not sure that you can achieve or reasonably approve, and always consult with an attorney if you are not sure. You always want to make sure you get this right.
Yeah. Very good. Thank you. So thank you as always, Leslie. Appreciate you walking us through this case. It really helps us understand the fair housing laws and making sure that we're doing everything we can to accommodate our residents, make sure we take good care of them. And for all of our viewers, if you found this video helpful, please like us, subscribe to us. We want to continue to give you more content like this. And if you're in property management, make sure you're staying on top of your fair housing training to avoid situations like this one. So thanks for watching, and we will see you next time. Take care, everyone.